Will the prosecution's change in tactics mean a different outcome this time around? Joining me now exclusively to help answer that question, Steve Haney, Jonathan Rinderknecht, criminal defense attorney. Steve, thanks so much for taking the time. I really appreciate it. So, first of all, are you surprised that prosecutors are going for a retrial? And why do you think they changed it up in this way, right? Dropping one of the charges and, focusing now at least on one charge on one fire.
Thank you for having me on, Jesse. I'm not surprised at all that they are retrying the case. It's a case of substantial magnitude. It needs some finality, and I believe that is what their aim is. I don't see there being much of a difference, frankly, between the two trials, and we'll have the same approach at the second trial that we did the first trial, and we have a lot of confidence going into November.
But the fact that they've now only focused on one of the charge on Lockman, not Palisades, is that easier for them? Is it a different kind of case for them to prove?
I wouldn't say it's easier. I think, at the end of the day, there's really nothing that changes. They need to establish or prove beyond a reasonable doubt at trial that Jonathan set the fire on January 1st, right after New Year's. And as we've maintained from the very beginning, we don't believe there's any direct evidence, and there never has been any direct evidence that Jonathan ignited any fire right after New Year's. So though they have changed the indictment, they have to do something different the second trial. You don't want to go in and have the same charging and the same facts and evidence and expect a different outcome.
Right.
I don't believe the modification will make a difference.
Do you think that it's acknowledging there was something lacking in their case? Do you think it's acknowledging they made a mistake? I mean, how could they not at least look at that verdict breakdown, almost verdict breakdown, and listen to the jurors' comments? I mean, in your mind, is it them acknowledging something was wrong in their case?
Well, I think, they have to acknowledge you can't have a 10-2 split for not guilty and not change things up. There obviously was an acknowledgement by them that charge 3 or count 3, timber set a fire. The fire ignited, and nobody disputes that the fire ignited on a state park. So there never was any federal jurisdiction with that count.
How do you plan to address, just for our viewers who are not familiar with this, how do you plan to address the circumstantial evidence, cell phone data, what was allegedly found in the car, things like that, that prosecutors would say allegedly ties him to igniting a fire?
Well, I mean, that cuts both ways. There's a mountain of circumstantial evidence as well that, he didn't set the fire right after New Year's. And, proving an arson case with circumstantial evidence and no direct evidence. When I say no direct evidence, no ignitable fluids, no confession, no witnesses. Look, they had 40 search warrants. They had all of his social media, all of his electronics. There was no evidence at all, any of that evidence or that production of those devices that indicated that he was involved or trying to hide a fire. So I think that, the evidence won't be much different at the second trial. And the outcome, I think, is going to be a real challenge.
How's he doing? How's he feeling right now about a second round?
He's very confident. I met with him last night in the jail, and we have a strategy going forward. We're not going to reveal it, obviously, here, but we'll get better too. Second trial, it's a two-way road. Government saw what we did. Well, we saw what they did. So we're going to make some improvements, and Jonathan's pretty encouraged.
By the way, why did they drop this timber set a fire charge? What was specific about that one? Why do you think they dropped that one? And by the way, them dropping that specific charge, does that change your defense at all?
Well, no. I mean, the fire ignited on a state park, right? So it always was curious to me why timber set a fire, which the elements are that the fire was ignited on federal land, which clearly the 10 acres of brush that burned January 1st from the Lockman fire was all state land. So I don't think they had any choice but to dismiss that count because there's no federal jurisdiction for an act a fire that was ignited on a state park. There's no federal jurisdiction. So it was not a surprise that ultimately that count would be dismissed either by them or eventually by the judge or jury.
I'm going to ask you a question that I'm pretty sure you're not going to be able to answer, but I'm going to ask it anyway because I've seen it in other cases when there's a retrial. Was there a conversation after the mistrial and before this new indictment that was he offered a deal at all?
I can't answer that question, but look, he didn't set the fire January 1st, and that's our strong belief, and we believe we'll prove that again in November.
Okay, well, listen, you got an open platform here. Thank you so much for being generous with your time, coming on exclusively to talk about this. Because, look, there's a lot of eyeballs on this. There's a lot of people that are focused on this. There's a lot of questions about how this even happened, where the responsibility goes. I mentioned what one of the jurors said about the first responders. So, Steve Haney, thank you for taking the time. We'll be watching.
Thank you, Jesse. I appreciate it.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.